Welcome to the Exhibit A podcast.
Looks like we're live. Welcome, Tom Daly. How are you today?
I'm great. Thanks for having me.
Thanks for coming. I know that you're a very, very busy guy, and we're going to talk about how you manage that crazy schedule that you do. I'm always in awe of you. Look, just for the audience's sake here, let's talk about what the topic's going to be today. And it's going to be how intellectual property issues intersect with family law cases. And the reason why we brought in Tom, who is a very dear friend of mine, is that he is an intellectual property attorney of many years. Tom, when people come to me and they ask me what I do, I tell them I'm a family law attorney, and you can imagine what they say. It's like, why in the heck are you doing that law, man? You know, you're dealing with all the people with personal problems, and I'm sure that they, drive you crazy with their problems, and they're, a little bit insane sometimes, and, you used to be a cop and why in the world are you a family law attorney? And I find myself having to justify it. And of course, I have my good reasons for doing so, but I suspect when people ask you what you do, you get that kind of cool, awe response, man. You're an IP attorney? You do intellectual property. Am I right?
Yeah. No, we feel like we're very productive.
No, you're understating it. You feel like you're at the top of the food chain, man. Like, come on, man. Right? So, I mean, the thing is with intellectual property attorneys is that, if you're talking about any type of an attorney out there, I think that intellectual property attorneys really are considered to be like the top of the educated, top of the food chain with respect to the complexity. You guys deal with a lot of things that most attorneys won't even can't touch because of what you do. And I'd like to talk to you a little bit about that. Let's start off with, what does it take to be an intellectual property attorney?
Well, usually when you talk about an intellectual property attorney, you're talking about someone who is registered to practice before
That's what I'm talking about, yeah.
The U.S. Patent and Trademark Office.
Yeah.
And to get registered before the U.S. Patent and Trademark Office, you have to have a technical background. So I have a chemical engineering degree, and so most of the people that I work with in the IP field, they have a science degree or an engineering degree. And then you have to go to law school if you want to be a patent attorney. So you have to have that technical side, and you also have to have the law side.
You guys have to take a separate exam, right?
We do, yeah.
Okay, and where is that?
It's now done online. When back in the day, when I had to take it, I had to go down to Irvine and go to a testing facility, and kind of like you do with the bar exam, where you go in, you sit down, you have to take the exam.
And it's to be licensed to practice in family court for intellectual. Is that what it is, or is it with the patent office? What are you certifying to become or licensing to become?
Yeah, it's handled by the patent office itself.
Okay.
And you get registered. It's a one-day exam. They have a morning session where I'm talking about when I took it.
Sure.
In the morning session, you had to answer basically true and false, multiple choice questions. And then in the afternoon, you actually had to write essays, and you had to draft a claim.
Are they testing you on your knowledge of IP law, or is it more like, on your technical background?
Not on your technical background. It's basically all about your knowledge of intellectual property law, patent law.
Okay. Okay, cool. All right, so let's a little dig into your background here, because I've always found you to be so fascinating and understated. You have a degree from the University of Illinois.
Illini.
That's right.
Go Illini.
And your degree's in chemistry?
Chemical engineering.
Oh my God. Okay. So, Tom, like me.
Chemistry are like bakers, and chemical engineers are like plumbers.
I thought you were going to say they're more like chefs, high stakes or something like that. Plumbers, come on, Tom.
Yeah. I can follow, because of my chemistry background, I can follow recipes.
Okay.
But if you give me a bad recipe, I'm going to make a bad batch of whatever.
Okay. So you, like me, are from Chicago. You're from the north side.
Yeah.
I'm
a Cubs fan.
Was. You were, okay, because you and I are both Dodgers fans. We've attended the games together. We both decided we're Dodgers over Cubs. That's right. You're a hardcore Bears fan.
Still a Bears fan.
Okay. You come from a large Catholic family.
Yes.
6 kids.
7.
7 kids. Oh my God. Okay,
I'm
you were
the
the
oldest
oldest.
of 7.
Okay,
Yeah.
which probably explains why you're the overachiever that you are. Although you're so calm and understated, but you're the typical oldest child where you just went out and did all kinds of things. So you become this chemical engineer from the University of Illinois, and you started actually in that profession, and you worked there for several years, right?
I did. Worked for PPG Industries in Pittsburgh, Pennsylvania. Worked in their coatings and resins division.
Okay. Now, what's hilarious to me is you've never seen the movie Breaking Bad, right?
I haven't.
Okay, but I know that at least I've told you this. You remind me of the character in there because he was a chemical guy and stuff. But, and I also say this is Thomas is so smart that being a chemical engineer was just too easy for him, so he decided to become a patent attorney, right? What was it that led you to become an attorney? Because it seems to me that there must have been a moment or something that you said, I want to do something else.
Well, I became a chemical engineer because my dad's a chemical engineer, and I didn't really know what I wanted to do. And so, he had done very well. He was able to afford to raise 7 kids. And so I thought, okay, I'll do that. And I remember at the University of Illinois, I was in my 4th year, and I was doing fine. But one of our friends came back, and he had already been out a year, and he was talking about what he was doing and how he loved just doing engineering and working on all those math problems. And I was thinking, this really isn't what I want to do. I had a buddy who was pre-law, and I liked talking with him about what he was doing. So when I got out, I went and I took an engineering job. I worked for PPG, and the auto industry went south, and I got laid off. And so I was thinking about what I wanted to do with my life, and I took another engineering job out in LA. And I did that because I knew I could go to law school in the evening.
Oh, that's what brought you out here. I didn't know that. Okay,
Yeah.
Interesting. Yeah, that was one of the questions I was going to ask you because I knew that when you came here you were an engineer, but shortly thereafter you were in Loyola Law School.
Right.
Right. And looking at your resume, I didn't know this about you: is that you were the editor of the Law Review when you were in law school.
Right. I was an articles editor. Right.
Oh my God. Yeah, and you're currently the editor of the LA County of a magazine. Which magazine is it?
Yeah, Los Angeles Lawyer. It's the magazine for the LA County Bar Association.
Okay, and I'm not going to go through all of your accolades because I'd be sitting here, 30 minutes talking into this thing. But some of the things that our viewers should know about Tom is that he's a natural-born leader. And he does it so effortlessly. I sit on a lot of boards with Tom. He's the past president of the Pasadena Bar Association. He is the past president of the Cancer Support Community Center. He's extremely active within the community. Past chair of the Pasadena Chamber of Commerce, where he served like 1.5 terms. He leads a provisors group. Tom is extremely active, and like I said, it's funny because he does it without breaking a sweat. At least it seems like. I mean, maybe internally you're screaming into the pillow type of a thing, but outside you seem like you do it. And I have to say that, like I said, I've sat a lot of boards, and you're just a natural leader. What do you do to manage your time? I know that you don't watch TV. You're a big reader, but how do you handle all this stuff? Is there any secret that you could impart upon us?
No, I mean, I obviously I keep control of my schedule, so I have to know where I'm supposed to be and what I'm supposed to be doing at any given time. But when I'm doing it, I just try to be there in the moment. I mean, I can't be thinking about what I'm going to be doing next. I have to think about what I'm doing now. So I just try to stay focused on what I'm doing and accomplish the task that's in front of me.
That's very interesting. When I stay in the moment, I lose track of time, then I'm way behind and I miss appointments. So you got something else there. Okay, let's talk about intellectual property, if you don't mind.
Sure.
Okay, because a lot of our clients out there and a lot of our viewers are really interested in this stuff. As a family law attorney, I'm dealing a lot with married people that have businesses, or we represent artists, all kinds of people that may have intellectual property issues in their family law cases. So to start off with, and this is something that I need because I took one class in law school concerning this stuff, is a brief description. What is a patent, a copyright, and a trademark? Because a lot of times we lay people get those things confused.
Right. So let's start with a copyright. A copyright is something that protects an original work of authorship. Authorship is a broader term than necessarily just writing. But if you are involved in creating a play or a movie or writing a book or painting a picture, all of those kinds of things can be protected with a copyright. A trademark is something that identifies a source and distinguishes it from this other source of other goods. Coca-Cola is a very well-known trademark. So when you're thinking about a trademark, you're thinking about something that tells you who supplied this product or service, and it helps to identify who that is and distinguish it from others who provide services or goods. When you get to a patent is an invention. Most people, when they think about patents, they think about utility patents, and that does cover how something functions, or a chemical, a new chemical that someone's developed. And then the third type of patents is a plant patent, which covers things like rose varieties.
Okay, all right. So how do people get protection from these three things? Are they all the same? They go to the same place?
No. The U.S. Patent and Trademark Office handles patents and trademarks, but the Copyright Office takes care of copyrights. The Copyright Office is part of the Library of Congress, whereas the Patent and Trademark Office is part of the Commerce Department.
Okay. What about trademarks then?
Trademarks are with the U.S. Patent and Trademark Office. So they're also part of the Commerce Department.
Okay. And do people need to go through those departments to secure protection, or there's some state rights as well that people use?
For patents and copyrights, it's only at the federal level. For trademarks, you have both federal protection, and you can also go and get state trademark protection.
Okay.
So you can go to the California Secretary of State, and you can get a trademark registered in California.
Okay. What are some of the common pitfalls that people find themselves into when they're trying to do it themselves?
Well, there are certain timing issues. If you're trying to protect a patent, you got to do it within a 1-year time period from publicly disclosing the idea or offering the invention for sale. And so a lot of times people don't realize that they have to move quickly, and before they try and get protection, they've already lost the opportunity to get protection. So you have to be careful about, letting the cat out of the bag before you've adequately protected it.
Okay. It would seem to me then that anybody that's contemplating getting a patent, a copyright, or a trademark, it'd be really smart to go and consult with an intellectual property attorney, like just to find out what they need to do, even if they ended up not retaining, but to actually learn about the timing part of this. And it's kind of like what I do when people come to me that I've been served with papers. And it's like, well, we need to file a response. Don't sit on that.
And we're willing to talk with people. I mean, just to give people the basics. We have no problem with that.
Yeah. So there's other types of issues that intellectual property attorneys deal with. I know non-compete orders, or I guess they're called contracts, non-compete contracts, and then issues concerning royalty payments. You guys deal with a variety of other things. Are there other common issues that come to play a lot in your profession?
Sure. Well, we talked about patent, trademark, copyright, but another area of intellectual property is trade secrets. So if you develop information, that and that other people don't know, and it gives you an advantage in your business, so you can have a trade secret. So when you talk about non-disclosure agreements, you're basically trying to protect your trade secrets, trying to make sure that when you tell people about it, they can't go and reveal the idea to others and use it for their own purposes. So we do help people protect trade secrets and enter into agreements to prevent competition, at least through the use of those trade secrets. the state of California wants to encourage competition, and so non-compete agreements are actually very limited. They are not enforceable except in very specific circumstances.
Yeah, the area has to be very tight. You can't say you can't compete anywhere in the state of California. It may be appropriate. You can't in the city of Pasadena, but
Well, yeah, actually, some states allow limited non-competes. California does not allow non-competes at all. I mean,
Wow.
they're very pro-competition in California.
Okay, cool. So I guess if a husband and wife divorced then, and they've got a bakery, here in Lake Avenue in Pasadena, and a husband gets the business, and he's got to pay her for it. She could go across the street and then say, "Hey, I'm glad for the money because now I was a better baker out of the two anyways, and compete directly across the street." So beautiful. I like it. Okay, so let's talk about the courts that you find yourself in, as an intellectual property. You don't deal mostly with state courts, right?
No, as I mentioned, most like patent and copyright matters are only in the federal court, and so if we're involved in those matters, if we're enforcing patents, enforcing trademarks, we go into the federal court. You can have trade secrets be in state court, but there's now a Federal Trade Secret Act, so that can now be in federal court. Trademarks can be both state and federal, but a lot of times people prefer the federal courts. It's a more I don't know, stately.
Come on, say it. It's not as grimy. You go to the state
It's
court.
not a zoo.
Okay.
Let's say it that way.
Okay, that's true because they have decorum over there, right? Yeah, so
At least they think they do.
well, you've been in federal courts throughout the country. That's pretty impressive too. You've been in New York. I know. I remember you going to a trial on that not too long ago.
In Boston, but also Fresno. So
have you been in Chicago?
I haven't. I don't think I've been in San Francisco. I've been in Madison, Wisconsin, in Boston, New York, but yeah, no, I've never had to go back to Chicago.
Yeah. So in your practice, you do both transactional and litigation, and your firm is really a nationwide firm, right? It's centered, and you've got various offices throughout the country.
Yeah, we're not nationwide. We're Southwest.
Okay.
Our main office is in Phoenix, and we have an office in Denver, and then one here in the Los Angeles area.
Okay. And with respect to the type of work that you guys do, I know that you do transactional and litigation. You're kind of a rare bird to the extent that you've done both, and usually attorneys do one or the other. Could you talk to our audience about what transactional work, types of work that you would do? Who would come and see you, and what type of work would you do for them?
Sure. So, obtaining a patent, obtaining a trademark, obtaining a copyright, getting those registered, that we consider that transactional work. We're interacting with either the Copyright Office or the Patent and Trademark Office, but we're getting that protection for people. Once they have that protection, a lot of times they want to exploit it commercially. They want to derive some benefit, get some money from it. And so we'll help them enter into licensing agreements so that those are contracts where you're giving someone the right to use your intellectual property in a certain controlled way. And in return, they're going to pay you money. They're going to give you a royalty. They can either pay you up front. There can be payments over time, and we will get into negotiating those types of agreements, drafting them. We talked about non-disclosure agreements will help people if you have a company and you have employees and you want to make sure that those employees won't take your trade secrets after they leave. We can help you draft agreements with those employees.
Okay, and then litigation kind of speaks for itself. It's you go into trial when there's when people need to sue each other or go to type of thing. What are some of the common issues that you find yourself in trial over?
Typically you'll have a situation where someone has a patent, either utility patent, design patent, and someone sees the product in the marketplace. They like the product. It's making money. It's very successful. And so they want to, get some, kind of get a free ride on that and, make some money. And so they'll copy it. A lot of times they won't, exactly copy it, although that sometimes happens. But they'll try and change it a little bit. But then the debate is did you change it enough, or are you still infringing on the intellectual property rights that cover the product? Whether it be did you pick a trademark that was confusingly similar? Did you come up with a design that is still too close to the patented design? Are you using a method that is covered by someone's patent? And so that's what we get involved in.
And I remember you telling me about some of those issues. But what I want to do at this time, Tom, is talk a little bit about family law cases. I know that you have previously assisted family law attorneys in helping in some of the areas. How have you helped family law attorneys? And family law clients, I should say, more importantly.
Well, sometimes the property that has to be divided up is intellectual property, and the question is, who owns that intellectual property? How exactly do you identify that intellectual property, and then how do you divide it up? What's the best way to approach dividing it up? And some of it is as simple as if we're going to divide it up, where do we record the documents that show who now owns that intellectual property? A lot of people will think about recording things with the Secretary of State, but they don't think about the fact that when it comes to intellectual property, you have to be recording it with the Copyright Office or with the U.S. Patent and Trademark Office. So they need to know about the fact that you've adjusted the ownership of the intellectual property.
Yeah, and I know that at least in our firm, we've had you assist us in preparing judgments, because wording with regard to intellectual property has to be pretty specific, right?
It should be. I mean, you want to be clear. You want to make sure that you've adequately identified it, and that people aren't going to be confused later about what actually was transferred and to whom.
Yeah, and then you've also assisted family law attorneys in litigation where there's a question as to whether or not a particular invention or creation is actually separate versus community property, right?
Yeah, as I've found out, timing is everything in family law. You have the date of marriage and date of separation, and so sometimes when intellectual property arises is going to depend on when it was, for example, when it was invented, what the date of invention was. And so I can help a family law attorney identify how that date of invention coordinates or matches with, let's say, a date of marriage or a date of separation, because it could be important in determining whether if the date of invention is before the date of marriage, then it might be separate property, whereas if it's after the date of marriage, then it may well be community property.
Okay, let me give you a hypothetical. This is law school time, man. I get to be the professor. I know nothing about this stuff. Okay, let's assume that you've got a very, very bright scientist, okay, and he works for a company in the area, and he's not married, okay? And he's got all the time in the world, okay? And he's got the highest degrees, in Harvard, and he's got these accolades. He's published articles and things, and he devotes a good 7 years to the cure for cancer.
Right.
Okay, and he works on it, and he's he comes up with this light bulb idea, and his employer goes, "Wow, man, we're going to patent this, right?"
Mm-hmm.
Now it hasn't really cured cancer yet, but he's got this idea, and he's got enough to get a patent. And as he's getting ready to get his bonus and everything else, he says, "Now's the time to get married because I'm successful." Okay, so he's 7 years working on it, gets married. After marriage, he and his team at the company continue working for this invention, and then unfortunately, like a lot of my clients, his marriage doesn't work out, and 4 years later, he's got to get a divorce. And during the divorce proceedings, wife says, "Hey, you're going to get royalty payments from this someday. You're not getting them now, but someday you're going to get these royalty payments, and they should be community because you worked on this during the marriage." So the whole issue in this case is what?
Well, yeah, there's a lot of issues there. One of the things that I would want to take a look at is the contract. Usually when you're working for a company, you have a contract that controls who's going to own the intellectual property.
Mm.
And it won't surprise you that most companies will require that their employees assign the intellectual property to the company. And so it's very likely that the scientist will have entered into an agreement where he has to assign that intellectual property. And if that agreement requires assignment at the very instant of creation, so when he first comes up with the idea, he may well be obligated to assign it to the company. And since that really is when he has to assign it, everything flows from that. So if he assigns it or is obligated to assign it before the marriage, then a lot of the things that happen subsequent to that really all kind of trace back to that pre-marriage situation. And you obviously are the family law expert, and you would have to kind of figure out how that entered into how that property would get divided up. But in my mind, you have a situation where kind of the key moment occurred before marriage, and then things that happened after marriage didn't change the fact that those royalties were owed. And a lot of what he was doing after the marriage was he was being compensated with his salary for doing those things. It was just part of his job to go ahead and continue to develop that invention.
So let me stop you there. So with your background, because especially since you've got a background in science, there's things that you would be able to look for pre-marriage that would be indicia of somebody really doing the work. What would be some of the things that you'd be looking for?
Well, a lot of inventors they'll be preparing notebooks, and those notebooks will show from day to day what kind of testing they were doing, what kind of experiments they were doing. Those are often dated and witnessed, and so we have the ability to go and look through those documents and see, how was this idea developing? What were the key moments when, that aha moment? Because we have an understanding of the technology, we're not going to be as bright as your
Harvard-educated, Nobel Peace Prize winner.
Yeah, no, the hypothetical scientist who's creating the invention, they're the smartest guys in the room.
Okay.
We're smart enough
to understand
that we can kind of figure out what they're talking about. Okay. And then we can look at the documents and we can help you understand when did that aha moment occur, and the timing of it then can enter into your evaluation of what's separate and what's community.
Okay, and this same type of assistance you have could apply to authors of books, producers of movies, anything that's regarding creation, and then the fighting over, trademarks, copyrights, things of that nature, right?
Yeah, I mean, my technical background wouldn't come as much into play if I'm looking at a book, but knowing the law.
Tom, what about a trivia book?
A trivia.
Yeah, you love trivia, and as we started talking before we started rolling today, I told you that there's a case of a guy who wrote a trivia book, during the time he was married. Okay, this is called Marriage of Worth, and what happened in this case is that he wrote the book, published it, profited from it, and then got a divorce, and his wife and he agreed that they would split the royalties. Okay, so there's no question about it. They went happily their own ways, right?
Okay.
What happens though is somebody out there in the world started infringing on the copyright, and the husband then sued, and he went after them on his own.
Sure.
And he started. He anticipated he was going to collect some money, and the wife says, "Excuse me, but when you collect those monies from the lawsuit, half of those are mine." Right? And the husband says, "No." So in this particular case, in Marriage of Worth, the Court of Appeal stated that hubby was wrong. Okay, that the issues, rents, profits theory, applies to lawsuits as well. So, in cases like that, in Marriage of Worth, I could easily see an intellectual property attorney like yourself getting involved to talk about when things were created and stuff, I guess. Although that one seems like it's pretty cut and dry, doesn't it?
Well, that to me is an interesting situation because I think it comes down to what the recovery was. So if the damages that the husband recovered were essentially lost royalties. So this infringer was basically depriving him of royalties. So he brings the lawsuit, and the recovery is for the royalties. So he had agreed to split those with his wife. So I think the court was right if, to the extent the recovery was for royalties, he had to split it. But I can see, what if his recovery, what if he happened to get, because this is copyright, and in copyright cases, you can recover your attorney's fees. So if part of the recovery was for his attorney's fees, I would think he'd get to keep those because he's the one that spent the money on the lawyers and funded the lawsuit.
Yeah. Or he could turn around and sue wife and say, you need to pay for half of this lawsuit, right?
Yeah.
Okay, let's change topics, okay? Because we've been talking, this has gone by way too fast. But I want to talk to you about some recent things that I've seen on the internet. First of all, you are a coin collector. You're an expert in coins. I've seen your coin collection, and I've even received a couple of coins from you as gifts. Attended your seminars and things like that. So, like I said,
everyone's got to have a hobby.
Yeah, well, I don't know where you get all the time that you do reading books and all that stuff, but in divorces, it's possible that people could be fighting over bitcoins. Okay, and what comes to mind for me, if you got a coin collection, you could get somebody to come out and appraise it and look at it, and experts could talk about what's the value and things like that. But what about bitcoins, man? How would you, do you have any idea how people would be able to value the bitcoins, if they're trying to divide it?
No.
I thought you knew everything, man.
Yeah, no. I mean, a Bitcoin is basically, it's like, I guess they've decided they're commodities. But it's represented by, I guess, a code. I mean, I guess you have a little, code that would tell you whether or not you have a
Do you own any bitcoins?
I own.
You don't have any in your collection?
I own no Bitcoin.
Okay.
I have no Bitcoin. But I know that, for example, one of the problems they have is if people lose that code, then no one even knows what the Bitcoin is or whether you have it or don't have it. I mean, that's supposed to be one of the upsides of it, is you can kind of hide it from people who might be trying to collect taxes on it. So,
with respect to discovery on bitcoins, I mean, I don't know if you know the answer to this or not, but how in the world would you try to find out if somebody has squirreled away Bitcoin somewhere?
I mean, I'm assuming you'd use your normal discovery in the sense of, you ask them and they have to respond under oath. But yeah, I assume there are also other computer forensic ways of finding out if they've been, because, people will have these virtual wallets where they store all their codes, where they would be keeping their Bitcoin. And so I'm assuming, I'm a chemical guy. I don't know computer. I don't know from computers.
No, but I like your creativity, though. You're a very creative guy, and that just answered us. You can look at the computer maybe and find it. So that's a good idea.
They got to store it somewhere.
Okay, all right. So the last issue of the day, is where were you 25 years ago? And we're seeing this in the news. I got called up from a recently I was called up from a television that wanted me to talk about this. I didn't have time for it, but O.J. Simpson's trial. The whole thing, that happened, I guess it was 25 years ago. Where were you when the chase happened?
I remember exactly where it was. I don't know if I want to reveal this.
Oh, okay.
But I was at a bar watching the NBA Finals.
There's nothing wrong with that.
Well, I mean, we were actually pretty upset because they kept breaking into the basketball game to show this ridiculous slow-speed chase with this white Bronco, and everyone, the commentators talking about it, and we're like, can't you get back to basketball? we got finals going on here.
That's funny. I was actually out on the road. I was in Orange County, and I remember the cars zipping past me. I didn't know what was going on because I didn't have the radio on or anything like that. And then I went someplace and what was that? And I found out and stuff. So, wouldn't you agree that was probably the craziest case in your life that you've ever seen, like in a public thing? I mean, we've seen a lot of things, but are there any bigger trials that you've ever seen?
Wow, it was certainly the showiest. I mean, you had to feel that everyone involved in that was playing to the cameras.
Yeah.
The judge seemed to be playing to the cameras, all of the attorneys, the witnesses. I guess I'm kind of glad that most of the cases that I get involved in are pretty low key.
Not televised?
They're not televised. We don't have a whole bunch of people, keeping an eye on it. it just is. It must have been really distracting to have to think about, what is how is the news going to play this? How am I going to look on camera?
Yeah.
I want to be thinking about how can I win this case for my client?
Yeah.
So,
Wait, one of the things that you said about this case to me is that you thought this was the ultimate Loyola versus Southwestern School of Laws because of the people on each
you're
side.
You're going to go there, aren't you?
Well, here's the thing. I was devastated by but you had a little reason to be happy at the end of these things, right?
Well, I'm a Loyola guy. I went to Loyola
right.
Law School, I think.
And I went to Southwestern.
Went to Southwestern.
You beat us.
Yeah, most of the defense attorneys were Loyola guys, and the prosecutors were Southwestern. So yeah, we did come out. Yeah, go Loyola.
Okay.
I don't know if we were on the right side, but we were on the winning side.
The winning side. Okay. Okay. We're gonna end it here. Unfortunately, I could talk with you, Tom, for hours, and I usually do. So thank you again for joining us. This was season 2, I guess, episode 1 of our Exhibit A, and we'll see you next time.
All right, thanks.
Exhibit A is produced by David Lindley at the law offices of Donald P. Schweitzer in Pasadena, California. For more information, visit us online at PasadenaLawOffice.com and all social media platforms.